Hello friends, welcome to EduTap and also welcome to the series that we have launched, that is 15 MCQs a day related to UPSC EPFO 2025, because we are expecting the notification of UPSC EPFO very soon, and as part of which part 1 हमने complete किया था earlier of labor laws of payment of wages act 1936. आज हम लोग उसी में part 2 करने वाले हैं. So friends, part 1 में हमने section 9 तक कुछ questions किए हैं. Whatever the revision that we have done related to the content, we have done is in the form of MCQs. So today also we'll be doing in the same manner, and उसमें आज हम लोग और 15 questions करने वाले हैं. So the number 1 question for today is, consider the following statements regarding section 10 of the Payment of Wages Act 1936 related to deduction for damage or loss. अगर उन्होंने कुछ डैमेज किया, लॉस कुछ किया है, उसके लिए डिडक्शंस किस तरह से करना है. तो उसमें 3 स्टेटमेंट्स मैंने यहाँ दिया है एंड आपको ये बताना है कि इसमें कौन सा स्टेटमेंट करेक्ट है. सो ए डिडक्शन फॉर डैमेज और लॉस कॉज्ड बाय एन एम्प्लॉयज नेग्लिजेंस और डिफॉल्ट शैल नॉट एक्सीड द एक्चुअल अमाउंट ऑफ द डैमेज और लॉस. Deductions can be made without providing the employee an opportunity to show cause against the deduction as long as the employer follows the prescribed procedures. Third statement ये है कि all deductions and collections must be recorded in a register maintained by the person responsible for wage payments. So ये तीनों statements में first yes it is true. ओके जितना लॉस हुआ उतना ही डिडक्ट करना, ऐसा नहीं कि कुछ ज्यादा कर रहे हैं. ओके एंड दिस इज फॉल्स बिकॉज चांस उनको देना चाहिए एम्प्लॉय को कि क्यों हुआ है, वो रियल में बड़ा एरर था या फिर कुछ और एक्सीडेंटल या कुछ हुआ है, दैट दे हैव टू अंडरस्टैंड बिफोर अप्लाइंग द डिडक्शन फॉर द लॉस और डैमेज. तो ये फॉल्स है. थर्ड, yes, all deductions and collections must be recorded in a register maintained by the person who is responsible for all these wage payments. फैक्ट्री में कोई मैनेजर हो सकता है, किसी और इसमें एस्टेब्लिशमेंट में कोई सुपरवाइजर हो सकता है या कॉन्ट्रैक्ट एम्प्लॉय हो सकता है, जो भी उस पर्टिकुलर काम के लिए है, जो वेज पेमेंट्स करता है. ठीक है. सो इन दिस केस ओनली 1 and 3 आर ओनली करेक्ट. So here comes question number 2, which says, consider the following statements regarding section 11 of the Payment of Wages Act 1936 related to deductions for services rendered. किस तरह के services? Statement ये कहता है, statement 1, deductions for services rendered such as house accommodation or amenities can only be made if the employee has explicitly accepted these services as part of their employment terms or otherwise. 2, second statement है, the value of deductions for such services must not exceed the market rate for similar services available to the general public. जो general public के लिए है उसी market rate से होना चाहिए. थर्ड स्टेटमेंट ये कहता है, the deduction amount shall not exceed the equivalent value of the house accommodation, amenity or the service provided. So in this case the first one it is true until and unless employee accept करेगा तब तक they can't deduct any amount for such services. 1, the value of deductions जो services है, it should not exceed market rate. market rate का कुछ यहाँ आता ही नहीं है. okay, it only says the amount shall not exceed the equivalent value of the house accommodation, amenity or service that has been provided. जो भी उन्होंने रेट तय किया था, it's not that वो market rate के हिसाब से ही होना चाहिए, nothing like that. So this statement 2 is false, only statement 1 and 2 are true here. So the correct answer here is B, 1 and 3 only. Next comes, as per section 12, now what is section 12 of the Payment of Wages Act 1936 related to deductions for the recovery of advances. Advances given before employment must be recovered from the first payment of wages for max of what period except for advances related to travel expenses. So अगर कभी कभी होता है कि ज्वाइन करने से पहले ही कुछ एडवांसेस लिया है, राइट, तो उस टाइम पे उन जो भी एडवांसेस दिया है उसको किस तरह से रिकवर किया जाए, व्हेन. ओके, सो इसमें ये दिया है कि इट मस्ट बी रिकवर्ड फ्रॉम द फर्स्ट पेमेंट ऑफ वेजेस, जो भी उसका फर्स्ट पेमेंट होगा वेजेस का उसी टाइम पे, फॉर मैक्सिमम ऑफ व्हाट पीरियड, वो पीरियड कितना होना चाहिए. सो इन दिस केस ऑलवेज इट वुड बी फॉर अ कंप्लीट वेज पीरियड, जो हमने इससे पहले डिस्कस किया था एक बार लास्ट सेशन में कि वेज पीरियड क्या है. सो वेज पीरियड ऑलवेज इट शुड नॉट बी मोर देन अ मंथ. सो ऑब्वियसली द कंप्लीट वेज पीरियड यहाँ पे इसका मतलब होगा 1 month ही. ठीक है. Now here comes question number 4. Under section 13A of Payment of Wages Act 1936, regarding the maintenance of the registers and records, which of the following statements is or are incorrect? Okay. Now employees are required to maintain registers and records detailing employee information, work performed, wages paid and deductions. These records must include receipts and other particulars prescribed by the appropriate government. Employees are exempt from maintaining records for employees earning above a certain threshold as prescribed by the central government. All records must be preserved for a minimum of 3 years from the date of last entry. So इसमें yes they have to maintain records, which is very much true. उनका काम क्या है, किस तरह का wages pay किया है, deductions कुछ किया है, fines, everything they have to maintain. And the records must include receipts and any other particulars prescribed by the appropriate government based on the industry they are up to. Third, employers are exempt from maintaining such records for certain threshold, above certain threshold, etc. This is not true because it is applicable for everyone and all records must be preserved for a minimum of 3 years from the date of last entry. वो entry हमेशा जो भी entry होगा वो at least 3 years तक उनको record maintain करना पड़ेगा. So here comes the next question, question number 5. Under section 14 of the Payment of Wages Act 1936 regarding inspectors, okay, जिनको अपॉइंट करती है अप्रोप्रिएट गवर्नमेंट सो दैट जो टाइम टू टाइम जो चेकिंग वो सब हो सके, वो सब ये कर लेंगे. विच ऑफ द फॉलोइंग स्टेटमेंट्स इज और आर इनकरेक्ट? Inspectors of factories under the Factories Act 1948 also serve as inspectors under the Payments of Wages Act 1936 for factories within their jurisdictions. And yes, this is true क्योंकि वो दोनों तरफ से वो काम कर सकते हैं. At the same time, they are also considered as a public servant when they are dealing in such work. Okay, inspectors can seize or make copies of registered documents or relevant portions if they reason to believe that an employer has committed an offence under this act. Yes, they can do this as well. And जब ये search, seizures ये सब करते हैं, this all comes under the provisions of Code of Criminal Procedures. Code of Criminal Procedures CCRP के अंडर 1973 का है. लेकिन आज recently this has been changed into भारतीय नागरिक सुरक्षा संहिता BNSS, अभी इसके अंडर आता है ये. Okay, now next, inspectors may oversee the payment of wages to individuals employed on a railway or in a factory or in an industry or an establishment. Yes, this is also true. वो कर सकते हैं उस तरह से. They have every right to do that. Inspectors have the authority to demand the presentation of registers or records to a verbal order at any location they choose. Yes, they can order the presentation, to demand the presentation of registers or records कहीं पे भी, but only through some written order. कुछ written request order के हिसाब से ही होता है. It's not based on the verbal order. So this is false. Rest of them are true. So this is the incorrect statement that we are talking about under section 14 of the Payment of Wages Act. So friends, here comes the next question. Under section 15 of the Payment of Wages Act 1936, which of the following authorities can hear and adjudicate claims arising from wage deductions or delays in wage payments? Already ये law किया ही है, ये act ये किया ही है to avoid all these, right, to give some protection to the employees in related to the wage payments or any wage deductions etc. लेकिन फिर भी कभी कभी हो जाता है, कुछ complaints आ जाते हैं, then where should the claims? So all the claims arising out of the deductions from wages or delay in payment of wages and penalty for malicious claims etc. all will fall under this section 15 of the Payment of Wages Act 1936. So इसमें कुछ statements and you have to tell me which statement is true in this case, or who can who is a authority who can look into this. Only labor courts constituted under the Industrial Disputes Act 1947. Any commissioner for workmen's compensation, regional labor commissioner or assistant labor commissioner with at least 2 years of experience. Only civil courts having jurisdiction over the area where the employer is located. Any officer of the central government not below the rank of deputy secretary. So in all this, B is the true one. Any commissioner of workmen's compensation, regional labor commissioner or assistant labor commissioner, but they should have at least 2 years of experience in order to look into this kind of complaints. Okay. Moving on to our next question from the same section. Section 15 of the Payment of Wages Act 1936 stipulates that applications for redressal of grievances related to unauthorized deductions or delayed payment of wages must be submitted within a specified time frame. Okay, एक time देते हैं और कुछ procedure होता है that they have to follow. Now considering that एक scenario दिया है, based on that you have to answer a question. Now scenario इस तरह से है. Ramesh, an employee, alleges that his employer deducted rupees 5,000 from his wages without authorization 10 months ago. Ramesh's trade union representative Rohan wants to file an application for redress on Ramesh's behalf. Now, which of the following statements is correct regarding Rohan's application for redress? First, Rohan can file the application within next 2 months, as the 12-month period for submitting applications has not yet expired. Rohan cannot file the application as a 10-month period for submitting applications has expired. Rohan can file the application but will be considered only if Ramesh provides a written authorization to Rohan within the next 30 days. 10 months हो गया है, अभी next 30 days में उसको देना है, तब भी वो कर पाएगा. Rohan can file the application even after the expiry of the application but before 90 days, and if the authority is okay that if Rohan demonstrates a sufficient cause for the delay in applying, then he can do that. Okay. Now, if we'll look at one statement each. So Rohan can file application within the next 2 months, as a 12-month period for submitting application has not expired. So first thing you have to understand is application, ये कंप्लेंट या एप्लीकेशन कौन कर सकता है रिलेवेंट अथॉरिटी से? वो अफेक्टेड एम्प्लॉय खुद कर सकता है और अ लीगल प्रैक्टिशनर हु इज रिप्रेजेंटिंग द एम्प्लॉय दैट एम्प्लॉयड पर्सन और एन ऑफिशियल ऑफ ए रजिस्टर्ड ट्रेड यूनियन. सो इन दिस केस रोहन इज एन official registered with the trade union and he has been duly authorized in writing to act on behalf of Ramesh, so he can do that. Okay, if he has been authorized then definitely he can do that. It's not that Ramesh को ही जाके वो करना पड़ेगा. ठीक है, ये एक हो गया है. एंड अभी टाइम फ्रेम, कितना टाइम फ्रेम है? विदिन 12 मंथ्स. जब भी वो डिडक्शन हुआ वहां से 12 मंथ्स तक टाइम पीरियड रहता है इनको वो कंप्लेंट करने के लिए. सो यहाँ पे 10 मंथ्स हुआ है, सो 2 मंथ्स है. सो यस, दिस इज ट्रू. रोहन कैन नॉट फाइल एप्लीकेशन एज अ 10 मंथ पीरियड फॉर 10 मंथ है ही नहीं, 12 मंथ्स कहते हैं, ये फॉल्स है. Rohan can file the application but it is considered only if Ramesh provides written authorization to Rohan within the next 30 days. No, हमारे पास अभी भी 2 months और है. So within next 2 months अगर वो दे देता है then he can file, Rohan can file. So this is also false. Rohan can file the application even after the expiry of application but before 90 days. No, another 12 months is given in this case provided the employee has to show some sufficient cause for delay in approaching or delay in applying or filing for the cause. ठीक है, तो ये भी false है. Okay, here comes the next question. As per section 15 of the Payment of Wages Act 1936, it provides for the payment of compensation to employees in cases of delayed payment of wages. Now, which of the following statements is correct regarding the payment of compensation for delayed wages? Okay, both. अगर डिडक्ट हुआ है तो उसे किस तरह से वो क्लियर करेंगे, एंड अगर कुछ डिडक्ट हुआ है तो उसे किस तरह से करेंगे. सो द फर्स्ट स्टेटमेंट सेज द कंपेंसेशन पेएबल फॉर डिलेड वेजेस शैल नॉट एक्सीड 1500. सी, कई बार होता है कि डिले हो गया पेमेंट ओके, डिलेड पेमेंट अगर डिलेड वेजेस में ये 1500 से ज्यादा होना चाहिए. ओके, द कंपेंसेशन दैट कैन बी प्रोवाइडेड बेस्ड ऑन द ऑफिशियल जो भी वो डील कर रहे हैं एंड गिविंग द डायरेक्टिव टू द एम्प्लॉयर. सो इट शुड नॉट बी लेस देन 1500 बट not more than 3000. So this is true and this is false. Okay, next ये हो गया हमारा डिलेड वेजेस में. डिडक्टेड वेजेस में द कंपनसेशन पेबल फॉर डिडक्ट वेजेस शेल नॉट एक्सीड 5 times the amount of wages delayed or wages deducted. So in this case it's not 5 times, it is 10 times. 10 times से ज़्यादा नहीं होना चाहिए जो कंपनसेशन वो पेएबल है बेस्ड ऑन द डिडक्टेड वेजेस. कई बार ऐसा होता है कि वो कंप्लेंट करने गए हैं, अप्लाई कर दिया है, बट इन बिटवीन उनका वो डिडक्टेड अमाउंट जो भी है वो आ गया है. इवन इन दैट केस कंपेंसेशन 2000 तक वो उनको मिल सकता है, नॉट मोर देन दैट. सो दैट यू हैव टू अंडरस्टैंड. सो ये फॉल्स हो गया हमारा. Claims made under this act should ideally be resolved within 6 months from the date of registration of the claim by the authority, as long as it is practicably feasible to do so. ये 3 months का time है. Within 3 months they have to do that, they have to resolve this. But अगर दोनों parties, the employer and the employee, अगर मान रहे हैं तो उसे और आगे उसको लेके जा सकते हैं for an extension. They can go beyond this 3 months period as well, but not more than that. So this is also false. So only this statement is true in this case. Moving on to our next question from the same section again. Under section 15 of the Payment of Wages Act 1936, in case where an application is found to be malicious or vexatious, ईदर पार्टीज की तरफ से अगर कुछ गलत हुआ है, जानबूझ के उनको फंसाने की कोशिश कर रहे हैं या ऐसा कुछ है, malicious intent, in that case what is the maximum penalty that can be imposed on the person who is presenting that application, जिसने भी अप्लाई किया है? In that case it is rupees 375. That is a penalty that is imposed on the person presenting the application in a malicious or vexatious manner. Yes friends, moving on to the next question. Section 17 of Payment of Wages Act provides for appeals against orders or directions issued under the act. अगर कुछ उनको लग रहा है कि उनके साथ इंसाफ नहीं हुआ है या कुछ, they want to appeal against whatever that they have received the order, they can do that. Now, which of the following statements is correct regarding the appeal mechanism under section 17 of the Payment of Wages Act? The first thing, an appeal against an order in direction can be filed within 60 days from the date of order or the direction. As I said, yes, they can do, but not 60 days, it is 30 days. ठीक है. Next आता है, in a presidency town and elsewhere, an appeal is made to the district court only. Okay, it's not like that. अगर presidency town है तो then the appeal is made to the court of small causes, elsewhere it is made to the district court. So presidency towns इनके लिए it is made to the court of small causes. Okay, and elsewhere it is made to district court. So separate. So this is also not true. An employer or responsible party can file an appeal if the directed payment for wages and compensation exceeds 300 rupees or imposes a financial liability that exceeds 1000 rupees. Yes, this is true. They can do this. And an employed person can file an appeal. ये हो गया employer का. Now, an employed person can file an appeal if the total amount of wages claimed to have been withheld, जो wage delaying या फिर withheld वाला है, from them is less than 20. No, this is not less than 20, but this is greater than 20 for individuals. And अगर वो employed person एक group को belong करता है जिनके wages deduct किए गए हैं, in that case it should exceed rupees 50. In individual cases it should exceed rupees 20. In group cases, unpaid group अगर कुछ है, as part of the group his wages have also been deducted, in such cases it would be greater than rupees 50. Okay. Yes, now moving on to our next question. Question number 11. Section 17 of the Payment of Wages Act 1936 specifies the conditions under which an appeal can be filed against an order or direction issued under the Act. Who among the following can file an appeal under Section 17 of the Payment of Wages Act 1936 if the total amount of wages claimed to have been withheld from the employed persons exceeds rupees 50. So in this case, only the employed person themselves, any legal practitioner or any official of a registered trade union authorized in writing to act on behalf of the employed person, any inspector or other person acting with the permission of the authority appointed. So in this case, either of these can do. It's not that only the employed person himself can do. So he can also do, but other than that, एनी लीगल प्रैक्टिशनर और ऑफिशियल जो ट्रेड यूनियन ऑथराइज्ड पर्सन होगा वो भी कर सकते हैं, एंड एनी इंस्पेक्टर और एनी अदर पर्सन जो इन सब का वो देख रहे हैं परमिशन जो अथॉरिटी के हिसाब से, दे कैन डू दिस. So here comes another question to brush up whatever that we have done till now. As per the provisions of section 9 of the Payments of Wages Act 1936, if 10 or more persons are absent without any due notice or without any reasonable cause, how much maximum deduction can be made by an employer? Okay, so here the amount that can be deducted in such case should not exceed each person's wages for 8 days. So 8 days का वो wages deduct कर सकते हैं. So another question again to brush up what we have done till now. As per section 2 of the Payment of Wages Act 1936, wage does not include which of the following: bonuses not forming part of the remuneration or not part payable under an award, settlement or court order, value of household accommodation, utilities, medical assistance or other services excluded by the government, employer contribution to pensions or provident funds including accrued interest, sums paid to cover special employment related expenses, gratuities payable upon termination of employment. And we have seen that wage exclusively जो उसमें mention में है as per the explicitly mentioned as part of the contract, only that would be considered as wage, including अगर कुछ extra work किया है etc. all those. Otherwise all these that have been highlighted here, they are not considered as wage under the term wage as per the section 2 of the Payment of Wages Act. So now when we talk about the Payment of Wages Act 1936, what exactly it does, what exactly it regulates, वो भी तो important है. Yes, the Payment of Wages Act 1936 regulates the payment of wages to certain classes of employed persons. Which of the following statements is correct regarding the applicability of the Payment of Wages Act 1936? That applies to wage payments for individuals employed in factories, railways and industrial establishment irrespective of their monthly wages. Yes, it is for all this, but not irrespective. They have a certain amount. Okay, that applies to wage payments for individuals employed in factories, railways and industrial establishments only if their monthly wages do not exceed 60,000. जो amount है, but that's not 60,000. So this is also not true. The Act applies to wage payments for individuals employed in factories, railways and industrial establishments only if their monthly wages do not exceed 24,000. Now this is true. And the Act applies to all establishments including those in the service sector without any discrimination or any limit on the monthly wages. This is not true because already हमने वो देख लिया. This is exclusively applicable for factories, railways and industrial establishments where the wages do not exceed rupees 24,000. Okay. Now ये जो Payment of Wages Act है 1936 along with few other acts, okay, they have been very recently rationalized and subsumed under one of these following labor codes. Now, which among the following codes has been notified on 8th August 2019 in the provisions of the Payment of Wages Act 1936, which we have been discussing in the last two sessions? It is last one and this one. The Minimum Wages Act 1948, the Payment of Bonus Act 1965 and the Equal Remuneration Act 1976 have been rationalized and subsumed therein in one of these following codes. Which is that code? And here we are talking about the Code on Wages 2019. इसमें ये चारों acts subsume हो गए हैं and they have been rationalized as well. तो फ्रेंड्स अभी तक हमने क्वेश्चंस किया है कुछ 9 to 10 सेक्शंस में, बाकी सेक्शंस का हम लोग क्वेश्चंस करेंगे इन द नेक्स्ट पार्ट. सो अगर आप लोग यूपीएससी ईपीएफओ एपीएफसी के लिए या फिर ईओ और एओ 2025 के लिए प्रिपेयर कर रहे हैं, सो वी हैव 3 options for you as part of your preparation to help you out in your preparation or to guide you out in your preparation. एक तो है मास्टर कोर्स जिसमें आपको सब कुछ मिल जाएगा, लाइक योर वीडियोस रिकॉर्डेड, द कंटेंट इन द फॉर्म ऑफ रिकॉर्डेड वीडियोस, पीडीएफ्स, चैप्टर वाइज क्विजेस, उसके बाद प्रैक्टिस, मॉक टेस्ट, एवरीथिंग यू विल गेट एज पार्ट ऑफ द मास्टर कोर्स. ये उनके लिए है जो बिल्कुल अभी तैयारी स्टार्ट किए हैं और उनको सब कुछ कंटेंट एक जगह पे चाहिए. अलोंग विद दैट एक वीकली गाइडेंस सेशन भी होगा आप लोगों के लिए विद कुलदीप सर. उस टाइम एवरी वीक थर्सडे के दिन होगा, तो उसमें आपको वो जो भी आपके क्वेरीज है या क्वेश्चन है, एवरीथिंग ही विल बी लुकिंग इनटू. नेक्स्ट आता है टेस्ट सीरीज प्लस. इसमें थोड़ा सा कंटेंट, वीडियोस एक्सेट्रा, उसके साथ साथ आपको टेस्ट सीरीज भी मिलेगा. सो दैट ये उनके लिए ऑलरेडी कुछ कंटेंट उन्होंने, मैंने थोड़ा प्रिपरेशन किया है, बट येस दे वांट अगेन कंटेंट अलोंग विथ द टेस्ट सीरीज सो दैट दे कैन चेक आउट देमसेल्व्स कि वेयर दे स्टैंड इन देयर प्रिपरेशन. नाउ थर्ड एक्सक्लूसिव टेस्ट सीरीज उनके लिए है कि ऑलरेडी उन्होंने प्रिपेयर कर लिया है, बट नाउ दे वांट टू टेस्ट चेक देमसेल्व्स वेयर दे स्टैंड इन देयर प्रिपरेशन. तो उनके पास पूरा कंटेंट उन्होंने प्रिपेयर कर लिया, सो उनके लिए टेस्ट सीरीज बेस्ट ऑप्शन है, जहां पे वो अपने आप को चेक कर सकते हैं कि where they stand in their preparation. So all these courses exclusively for the upcoming UPSC EPFO both APFC and EO AO के लिए, that is for 2025, wherein we are expecting the notification sometime in Feb or March. Thank you very much and see you all in the next session soon. All the best.